Tonight, we examine a case that once commanded national attention and then passed by degrees into the more particular keeping of the law reports and the criminal histories. A single household, a single verdict, and a question that more than a century has not settled. The case of Katharine Mary Armstrong begins at Cusop in the county of Herefordshire in the closing weeks of the winter of 1921. Cusop is a small parish in the west of England, lying immediately upon the border with Wales, separated from the Welsh market town of Hay-on-Wye by little more than a narrow watercourse and the line that divides one country from the other. The parish in those years was a scattered place of houses set among fields and wooded ground, without the density of a town and without a town's noise. The land rose away to the south toward the Black Mountains, and the small river known as the Dewless ran through the wooded hollow called Cusop Dingle. It was in this hollow, upon rising ground, that the house called Mayfield stood in its own grounds. The house was large and settled and comfortable, an establishment of the professional middle class, kept with servants and maintained to a standard that the district understood and respected. A few hundred yards to the west, across the small river and across the border, lay Hay-on-Wye. The town was and remains a market town of modest size, seated in the county of Brecknock in Wales, upon the upper reaches of the River Wye. Its streets were narrow and close built, its trade the ordinary trade of a country town that served the farms around it. In the town were the offices of solicitors, the shop of the chemist, the premises of the auctioneer, and the small society of professional men who conducted the town's business and knew one another as neighbours know one another. The distance between the town in Wales and the house in England was short. A man might walk it in a few minutes. The two places, so near and yet divided by a border, form the two poles of the case, and the case turns in part upon the distance between them. The year was 1921, and the England and Wales of that year was a country only lately emerged from the Great War. The men who had served returned to civil life, carrying the ranks they had held in the field, and it was common for a man to be addressed still as captain or major years after the guns had fallen silent. The deference of the pre-war years had been shaken but not undone, and in a small country town, the old order of things, the professional man at the head of the town's affairs, the doctor and the solicitor and the clergyman as the settled figures of authority, remained largely in place. It was a society in which respectability was a currency, and in which a man's standing rested upon his office, his manner, and the good opinion of those among whom he lived. Into this settled world, at the house called Mayfield, the household of Katharine Mary Armstrong was ordered and maintained. She was, at the time with which this account is concerned, a woman of 48 years. The surviving record of her own life is comparatively thin, and much of what is known of her is known through the proceedings that followed her death, rather than through any account she left of herself. She has come down in the record, refracted through the testimony of others, through the recollection of servants and neighbours and the men of law, and this account must proceed with that limitation acknowledged. Katharine Armstrong was before her marriage a woman named Friend. Though the surviving record does not establish the particulars of her family of origin with certainty, and this account will not assert what it cannot confirm. What the record does establish is her character as it was observed by those who knew her. She was a woman of strict habit and settled principle. She was a total abstainer from alcohol, and she held that abstinence not merely for herself, but as a rule of her house. She was devout in her observances and correct in her conduct, and she was, by the general account of the town, the dominant figure in her marriage. The town observed the marriage with a certain quiet amusement, for the ordering of the household ran contrary to the expectation of the age. It was Katharine Armstrong who governed the domestic arrangements and set the rules by which the house was kept. It was said of her that she would call her husband away from a tennis party at 6 o'clock in the evening when she judged that the hour had come for him to return home. It was said that she forbade the serving of wine at her own table, and that her husband, a solicitor of standing in the town, submitted to these governances without open complaint. The record establishes these matters as they were recalled by witnesses, and this account states them as recollection, not as judgment upon either party. She had married Herbert Ruse Armstrong, a solicitor practising in Hay-on-Wye in the years before the war. Of that marriage, there were 3 children, all of them under age at the time with which this account is concerned, and all of them unharmed by the events that followed. The children appear in the record only in passing, and they passed in later years out of public notice altogether. This account will follow the record in leaving them there and will not pursue them. What Katharine Armstrong brought to the household was standing and propriety, the settled respectability of a well-ordered home. Her husband was the wage earner, a man of profession and public office in the town across the border. The house at Mayfield, with its grounds and its servants and its correct observances, was the visible sign of the family's place in the district. It was a place of order, and by every account of the years before her illness, it ran as an ordered house runs, without event and without remark. If you value cases told this way, drawn from records rather than speculation, subscribe to the channel. Now back to the record. The events with which this account is concerned had their beginning in the summer of the year 1920, when the ordered life of the household at Mayfield first departed from its long routine. In July of that year, Katharine Armstrong executed a new will. The instrument she signed left the whole of her estate to her husband, to him outright and absolutely, in place of an earlier arrangement under which her property would have been held for the benefit of the 3 children. The circumstances in which this will came to be made were afterwards subjected to close and searching examination, and the question of whether the instrument was in truth her own free act, or whether it was made under influence, became one of the contested matters of the case. This account states the fact of the will, as the record establishes it, and states also that the circumstances of its making were disputed, and it does not assert what the record does not settle. In the same season, Katharine Armstrong began to be unwell. The illness came upon her with vomiting and with a general failure of health, and there appeared in time a further and more particular symptom. She suffered a loss of sensation and of movement in her limbs, a weakness and numbness in the hands and feet that is, in the language of medicine, consistent with the condition known as peripheral neuritis. That condition is a recognised sign of the action of arsenic upon the body, though it may arise from other causes also, and at the time it was not understood by those about her as the sign of anything but a natural sickness. As the summer drew on, her condition grew worse rather than better, and it came to affect her mind as well as her body. In the month of August 1920, she was certified and removed from the house to Barnwood House, an establishment near the city of Gloucester, for the care of persons suffering disorder of the mind. There, away from Mayfield, and under the care of the institution, a change was observed in her. Removed from her own house, she recovered. Her strength returned in some measure, the symptoms that had troubled her abated, and by the turn of the year, she was judged well enough to return home. In January of the year 1921, Katharine Armstrong was brought back from Gloucester to the house at Cusop, and there she was nursed. A nurse attended her in the sick room, and the household ordered itself around her care, but the recovery that had marked her time in the institution did not hold. Once returned to Mayfield, she began again to decline. The vomiting returned, the weakness returned, and through the early weeks of the year, her condition worsened steadily, until it was plain to those about her that she was gravely ill. On the 22nd day of February, in the year 1921, Katharine Mary Armstrong died at Mayfield. She was 48 years of age. The medical man who had attended her was Dr. Tom Hinks, the family physician, and it fell to him to certify the cause of her death. He certified that she had died of gastritis, with a condition of the heart contributing. There was at that time no inquest, and no question was raised. She was buried in the ordinary way, mourned as a woman carried off by natural sickness, after a long decline, and the household at Mayfield was left in the keeping of her husband. So the matter stood, and so it might have remained, had it not been for events that arose some months afterward on the other side of the border, in the town of Hay. The man whose affairs would soon draw the attention of the country was Herbert Rouse Armstrong, the husband of the woman who had died at Mayfield. He was born in the month of May in the year 1869 in the West Country of England, in the neighbourhood of Devon, though the surviving record does not fix the exact town of his birth beyond dispute. He was educated at Cambridge at St Catherine's College, and he took up the profession of the law, qualifying and admitting himself as a solicitor. In his person he was a small man, slight of build and neat in his habits, weighing by common account little more than 7 stone. He was dapper in his dress and precise in his manner, a figure of quiet and unremarkable respectability. He had served in the Great War, though not in the trenches of the Western Front. He held a commission in the territorial force and rose in the course of the war to the rank of major, engaged in the main upon home service and the work of administration rather than upon the field of battle. The precise particulars of his unit are not established beyond question in the surviving record, and this account will not assert them. What is established is that he returned to civil life bearing the rank, and that he was known in the town of Hay thereafter as Major Armstrong, the title carried forward into his ordinary dealings, as was the custom of the age. In the town of Hay-on-Wye, he occupied a position of settled standing. He was a practising solicitor, and he held besides the office of clerk to the justices, the official who serves the magistrates and keeps the business of the local bench in order. He was, in the small society of the town, a man of consequence and good repute, one of the professional men whose word carried weight and whose respectability was not questioned. He was known, he was trusted, and he went about the town's business, as a man does who has held his place in it for years, without a shadow upon his name. Yet beneath the surface of this respectability, there ran, according to the case afterward advanced against him, certain pressures. There was the matter of the will his wife had made, under which he stood to inherit her estate outright. There was a rumour, never established as fact, of an entanglement or an attachment that gave him a motive to desire his freedom. And there was, in the professional sphere, a matter of business that had gone badly and left him exposed. These were the strands the prosecution would in time gather together and present as motive. This account sets them out as the theory of the prosecution, advanced at the trial and contested since, and not as established fact, for the question of motive in this case remains among the matters that history has not settled. The business matter that would prove the occasion of everything that followed concerned a rival solicitor in the town. His name was Oswald Martin, a younger man who practised in Hay, whose office stood across the narrow street from Armstrong's own. Between the two men there was a professional dispute, and it turned upon a transaction in land, a sale that had gone wrong. Armstrong was concerned in the matter on one side, and Martin on the other, and a sum of money, a client's deposit amounting by the general account to some £500, lay at the heart of it. Armstrong was exposed in the transaction, pressed to complete a sale that he was in no position to complete, and the dispute between the two solicitors grew sharp. Martin's father-in-law, it happened, was a man named John Davies who kept the chemist's shop in the town, and this circumstance would in time prove of the first importance. Through the summer and autumn of the year 1921, the pressure upon Armstrong in the matter of the land sale increased. Martin, acting for the purchaser, was entitled to press for completion, and Armstrong, unable to complete, sought to delay. It was in this season and against this background of professional difficulty that a series of events began, which drew suspicion at last upon the house at Cusop. In the month of October, in the year 1921, there arrived at the Martin household an anonymous gift. It was a box of chocolates, sent through the post without a sender's name, and it was received into the house and set aside without particular thought. In the ordinary course, some of the chocolates were eaten. A guest at the Martin household, a relative of the family staying in the house, ate of them and was afterward taken violently ill. The illness passed, and at the time it was not connected with the sweets, nor was any wrong suspected. The box was set aside, and a portion of its contents remained uneaten. That portion would afterward assume a significance that no one in the house could then have foreseen. Then came the occasion that would fix the case. On a day in the latter part of October, Armstrong invited Oswald Martin to take tea with him at Mayfield. The invitation was in itself unremarkable between two men of the same profession in the same small town, and Martin accepted and came to the house. At the tea table, Armstrong handed to his guest a buttered scone. The record preserves the words with which he did so, for they became among the most repeated words of the case. He passed the scone to Martin with the remark, "Excuse fingers." Martin ate the scone. That night, upon returning to his own home, Oswald Martin was seized with a violent illness, sickness and prostration, coming upon him with a sudden and alarming force. Martin's illness was severe enough to bring the doctor to him, and the doctor who attended him was the same Dr. Tom Hinks who had attended at Mayfield. The illness, its suddenness, and its violence set the physician thinking, and there was the further circumstance of the chemist. Martin's father-in-law, John Davies, keeper of the chemist's shop, recalled a matter that now took on a new colour. He recalled that he had sold to Mr. Armstrong a quantity of arsenic across the counter of the shop. Armstrong had bought it, according to the account, for the purpose of making a weed killer, to destroy the dandelions upon the lawns of Mayfield. The sale had been an ordinary one at the time, the sale of a common domestic poison for a common domestic use, entered in the poisons register, as the law required. But set beside the sudden illness of Oswald Martin after tea at Mayfield, and the earlier illness of the guest who had eaten the anonymous chocolates, the recollection of the sale of arsenic assumed a graver character. Suspicion, once formed, moved toward proof. The doctor and the younger solicitor, comparing what they knew, resolved that the matter should be tested rather than left to conjecture. A sample was taken from Martin, a specimen of his urine, to be sent away for analysis by those competent to detect the presence of poison. The remaining chocolates from the anonymous box were gathered up, and they too were sent for examination. The results, when they were returned, gave the suspicion a foundation. In fact, arsenic was found in the chocolates. The sweets that had been sent anonymously to the Martin household and that had made a guest violently ill were shown upon analysis to contain the poison. With that finding, the matter passed beyond the compass of a country town. The analysis was such as could not be ignored, and the proper authorities were informed. The Home Office was alerted to the case, and the investigation that followed was conducted with the involvement of officers from beyond the district, the resources of Scotland Yard being brought to bear upon a matter that had begun as the private suspicion of a doctor and a solicitor in a small town upon the Welsh border. The inquiry proceeded through the closing weeks of the year with a care appropriate to the gravity of what was suspected, for it now concerned not merely the illness of a living man, but, by inevitable extension, the death some months before of a woman at Mayfield, whose burial had been attended by no question at all. The investigation moved toward its first decisive act at the close of the year. On the last day of December, in the year 1921, Herbert Ruse Armstrong was arrested. The charge upon which he was taken was not, at that first stage, the murder of his wife, for that matter still lay unexamined beneath the ground at Cusop. The charge was the attempted murder of Oswald Martin, the living man whose sudden illness after tea at Mayfield had set the whole inquiry in motion. Armstrong was taken into custody, and his person and his premises were searched with the thoroughness that the gravity of the case demanded. Upon his person, when he was searched, the officers found a small packet of arsenic. It was a quantity of the poison carried loose upon him, and its presence upon the man at the moment of his arrest was a circumstance of the plainest significance. But it was the search of the house at Mayfield that produced the detail which would prove, in the months to come, the hardest of all the evidence for the defence to answer. At the house the officers found further arsenic, and they found it not in a single mass but made up. The poison had been divided into small individual doses, wrapped separately, some 20 little packets in all, each containing a measured quantity of arsenic. This was the detail that ran through the whole of the case thereafter. The 20 wrapped doses, the arsenic parcelled out into portions, a thing for which the man in whose house it was found would be called upon to give an account, and for which the account he gave was never found sufficient. With Armstrong in custody upon the charge concerning Martin, the investigation turned at last to the grave at Cusop. The suspicion that had gathered about the living could not be separated from the death of the woman who had been buried in February as one carried off by natural sickness. Application was made in the proper form, and authority was obtained for the exhumation of the body of Katharine Mary Armstrong. On the 2nd day of January, in the year 1922, some 10 months and more after her burial, her remains were raised from the ground that a competent examination might determine what had in truth been the cause of her death. The examination of the remains was entrusted to Sir Bernard Spilsbury, the pathologist whose name was by that date the most eminent in England in the medical service of the criminal law. He conducted his examination with the care and authority that his office required, and his findings were plain. He found arsenic in the body, and he found it in quantity. The amount recovered from the remains was measured at rather more than 3 grains, a quantity comfortably in excess of what is required to destroy a human life, and the poison was distributed through the body in a manner consistent with its having been taken into the system before death rather than introduced afterward. The medical restraint proper to such a matter requires no more than this. The cause of death was arsenical poisoning, established by competent examination, and the certificate that had been given the year before of gastritis and a failing heart was thereby overturned. The finding transformed the case altogether. What had begun as an inquiry into the illness of a living solicitor was now, and could not but be, an inquiry into a death. The woman who had been mourned and buried without a question, whose long decline had been read as the work of natural sickness, was shown by the examination of her remains to have died with a fatal quantity of arsenic in her body. The original certification stood discredited. The manner of her death was now a matter for the law to determine, and the man already in custody upon the charge concerning Martin stood in a graver danger than before. In the ordinary and proper course, a coroner's inquest was convened to inquire into the death of Katharine Armstrong. The inquest was held in the early weeks of the year 1922, following upon the exhumation and the examination of the remains, and it sat to determine, according to its ancient office, how the deceased had come by her death. The coroner heard the medical evidence, the findings of the examination, the account of the arsenic recovered from the body, and the circumstances of the long illness and the death at Mayfield. Upon that evidence the inquest returned its finding. It found that Katharine Mary Armstrong had died of arsenical poisoning, a death by the administration of poison, and not the natural death that had been certified the year before. The finding of the inquest, taken together with the matter already before the magistrates, brought the 2 strands of the case into a single channel. Armstrong, held upon the charge of the attempted murder of Oswald Martin, was now committed also upon the graver charge, the wilful murder of his wife. The committal proceedings were conducted before the magistrates at Hay, the court sitting to determine whether the evidence was such as to require that the accused be sent for trial. The evidence was laid before the bench. The medical findings, the recollection of the chemist, the circumstances of the illnesses, the arsenic found upon the man and in his house, and the magistrates determined that the case must go forward. Armstrong was committed to stand his trial at the assizes upon the charge of murder. The reflective summary of this stage of the case may be briefly stated. A death certified as natural had been shown by exhumation and competent medical examination to be a death by poison. A man arrested upon a charge concerning a living victim had been found, upon that examination, to stand accused also of the death of his wife. The inquest had returned its finding. The magistrates had committed the accused, and the matter now passed from the local courts to the assizes, where the whole of it would be tried before a judge and a jury of the county. The trial of Herbert Rose Armstrong was held at the assizes for the county of Hereford. It opened in the early days of April in the year 1922 and continued for the better part of a fortnight, drawing to the small county town the attention of the entire country, for the case of the poisoning solicitor had by then become a sensation of the national press. The judge who presided was Mr. Justice Darling, one of the most experienced of the judges of the day, a man of long service upon the bench and of a manner in court that was itself much remarked. The conduct of the trial, and in particular the conduct of the judge, would afterward become one of the matters upon which the case was debated, and this account will come to that in its place. The prosecution was led by the Attorney General himself, Sir Ernest Pollock, the first law officer of the Crown, whose appearance in the case was itself a measure of its gravity. For the Attorney General does not ordinarily lead in a trial upon assize save in a matter of the first importance. He was supported by junior counsel, and the whole weight of the Crown's case was marshalled under his direction. For the defence there appeared Sir Henry Curtis Bennet, a King's Counsel of the highest reputation at the criminal bar, a man practised in the defence of prisoners upon capital charges and skilled in the handling of a jury. The charge upon which Armstrong was arraigned was the murder of his wife, Katharine Mary Armstrong, and to that charge he pleaded that he was not guilty. The case for the Crown rested upon a body of circumstantial evidence, for there was no witness to any administration of poison, no person who had seen the accused give arsenic to his wife, or to any other. The Crown built its case from the several strands that the investigation had gathered. There was the arsenic recovered from the body of the deceased, established by the pathologist as a fatal quantity taken before death. There was the pattern of the illness itself, the sickness that had come upon her at home, that had abated when she was removed to the institution at Gloucester, and that had returned and deepened upon her return to Mayfield, a pattern the Crown urged as consistent with the administration of poison in the house, and its withdrawal in her absence from it. There was the sale of arsenic across the counter of the chemist's shop, and there was, above all, the arsenic found upon the accused at his arrest, and the 20 wrapped doses found within his house. To these strands the prosecution sought to add a further, and, as it proved, a decisive element. The Crown proposed to lay before the jury the evidence of the attempted poisoning of Oswald Martin, the buttered scone, the sudden illness, the anonymous chocolates, the whole of the matter concerning the living solicitor across the street. The defence resisted the admission of this evidence, and upon good ground, for the accused stood arraigned not for any offence against Martin, but for the murder of his wife, and the ordinary rule of the law was that a man must be tried for the offence charged, and not prejudiced by proof of other and separate acts. The question of whether the Martin evidence should be admitted was argued before the judge, and it was upon the resolution of that question that the trial in large measure turned. Mr. Justice Darling ruled that the evidence should be admitted. He held that the attempted poisoning of Martin might properly be laid before the jury, not as proof of a separate crime, but as evidence bearing upon the design and intent of the accused in the death of his wife, as showing a system, a disposition to the use of arsenic that rebutted any suggestion of accident or of innocent explanation. The ruling brought before the jury the entire matter of Martin, the scone and the words that accompanied it, the chocolates and the guest who had sickened, and it placed beside the death at Mayfield the near death of a living man by the same poison, and in circumstances connected to the same accused. The admission of that evidence is regarded to this day as among the landmark rulings in the English law of what is termed similar fact evidence, and it is widely held to have decided the case. This account states the matter as the record establishes it, that the ruling was made, that the evidence was admitted, and that its admission has been debated by lawyers ever since. The prosecution laid before the jury also the matter of the will, the instrument executed in July of 1920 by which the whole of the estate of Katharine Armstrong passed to her husband. The Crown urged the will as evidence of motive, the accused standing to gain by the death of his wife the property that the instrument secured to him, and it urged, besides the pressures of his professional situation, the failed transaction in land and the exposure it had brought upon him. This account has set out already that the question of motive in this case was contested, and it repeats that the will and the financial matters were advanced by the Crown as its theory of motive, and were not, and are not, matters that the record settles beyond dispute. The defence met the Crown's case upon each of its strands, to the arsenic bought at the chemist's shop, and to the 20 wrapped doses found at Mayfield. The defence offered an innocent explanation. Armstrong had bought the poison, it was said, for the destruction of weeds upon the lawns of his house, and he had divided it into small doses for a particular and innocent purpose, that each dose might be applied separately to a single dandelion or plantain in the turf, the poison placed at the root of each individual weed. To the illness and death of Katharine Armstrong, the defence offered the possibility of an innocent medical cause, and it raised also the possibility that the poison had been taken by the deceased herself, a woman who had suffered disorder of the mind, who had been an inmate of an institution, and who had access, in her own house and grounds, to the weed killer kept there. This account sets out the suggestion of self-administration as the record sets it out, as a possibility advanced by the defence, and not as a fact established, for it was not established, and the matter of the mind and suffering of Katharine Armstrong is one that this account approaches with care and without diagnosis. Herbert Rose Armstrong elected to give evidence upon his own behalf. He went into the witness box and submitted himself to examination and to cross-examination, and it was in the course of his cross-examination that the case reached its turning point. He gave his account of the arsenic, the weed killer, the destruction of the dandelions, the innocent purposes to which he said the poison had been put. He was pressed in particular upon the 20 little packets, the arsenic made up into individual doses and found within his house. He was asked to explain why the poison had been so divided, why a man buying weed killer for his lawn should have parcelled it into 20 separate wrapped portions. The explanation he gave was not found convincing. Under the pressure of cross-examination, he could not account satisfactorily for the 20 doses, and the failure of that explanation, before the jury and before the country that read the reports, told heavily against him. It is the detail that has followed the case through every account of it since. The small man in the witness box, unable to explain the 20 little packets of poison found in his house. The trial having run its course, the judge delivered his charge to the jury, and the jury retired to consider their verdict. They were absent from the court for a time, weighing the whole of the evidence that had been laid before them, the medical findings, the pattern of the illness, the arsenic upon the man, and in his house, the matter of Martin admitted by the ruling of the judge, and the failure of the accused to explain the doses. When they returned with their verdict. They found Herbert Rose Armstrong guilty of the murder of his wife. The reflective summary of the trial may be plainly stated. The case against the accused was circumstantial, resting upon no witness to the act, but built from the medical evidence, the pattern of the illness, the possession of the poison, and, by the ruling of the judge, the evidence of the separate matter concerning Oswald Martin. The accused gave evidence and could not explain the 20 wrapped doses. Upon the whole of that evidence, the jury found him guilty, and the case passed to its next stage, the passing of sentence, and to the aftermath that followed upon it. Upon the return of the verdict, the court proceeded to sentence. For the crime of murder, the law of that time provided one penalty only, and the judge, having heard the verdict of the jury, pronounced upon the prisoner the sentence of death. The sentence was received in a court crowded to its doors, and it was reported through a press that had followed every day of the trial and carried its proceedings to every part of the country. The case of the poisoning solicitor had gripped the nation through the winter and the spring, and the sentence of death upon Major Armstrong, a man of profession and standing, the clerk to the justices of his town, was the sensation of the season. The sentence did not at once become final, for the law allowed to the condemned man the recourse of appeal. Notice of appeal was given, and the case was carried to the Court of Criminal Appeal, where the conviction was examined upon the grounds urged on the prisoner's behalf, among them the admission of the Martin evidence and the conduct of the trial. The Court of Criminal Appeal considered the matter and dismissed the appeal. The conviction was upheld and the sentence of death stood. There remained the further recourse of a petition to the Home Secretary, in whom lay the power to advise the commutation of a capital sentence, and a petition was made for a reprieve. That petition also failed. The Home Secretary found no ground upon which to interfere with the course of the law, and the sentence was left to be carried out. The reflective summary of the sentencing and its immediate aftermath is this. The sentence of death, once pronounced, was subjected to the two recourses the law allowed, the appeal to the Court of Criminal Appeal and the petition to the Home Secretary, and both were refused. The conviction stood, the sentence stood, and the date of its execution was fixed. The whole of it proceeded in the full view of the country, and the man who had been for years a respected figure in a small border town awaited, in the condemned cell, the carrying out of the sentence of the law. The execution was carried out on the last day of May in the year 1922 at Gloucester Prison, within whose walls the condemned man had been held. The office of executioner was discharged by John Ellis, the hangman who served the law of England in those years, assisted by an assistant executioner whose identity the surviving record does not fix beyond question. The sentence was performed in the manner and with the privacy that the law of that time prescribed, within the precincts of the prison and without public view. The body was buried according to the custom that governed the burial of those executed under sentence of law, within the ground of the prison itself. So ended the life of Herbert Ruse Armstrong in the 53rd year of his age. There attaches to his execution a distinction that has fixed the case in the memory of the profession he had followed. Herbert Ruse Armstrong is the only solicitor in the history of England ever to have been hanged for murder. A man of the law, an officer of the court, the clerk to the justices of his town, he passed from the bench where he had served the magistrates to the dock, and from the dock to the condemned cell and the scaffold. That a member of the legal profession, and one who had held a judicial office in his district, should have been convicted and executed for the poisoning of his wife, gave to the case from the first a particular hold upon the public mind, and it is by that circumstance, as much as by any other, that the name of Armstrong has been remembered. The case did not close with the execution, for it entered almost at once and has never left. The long dispute over whether the verdict of the court was a safe one. The conviction rested, as has been set out, upon evidence wholly circumstantial as to the death of Katharine Armstrong, upon the admitted evidence of the separate matter concerning Martin, and upon the failure of the accused to explain the 20 wrapped doses. Each of these foundations has been examined and re-examined in the century since, and about each of them a question has been raised. This account has stated the conviction as the verdict of the court, for that it is entered in law and never in law reversed. It states now, with the same fidelity to the record, that the safety of that verdict has been seriously and enduringly debated, and that the debate is not the province of cranks, but of careful and qualified writers. The most sustained of the challenges to the conviction was made by a writer named Martin Beales, himself a solicitor, who came in later years to live at Mayfield, the very house in which Katharine Armstrong had died. In a book issued under the title Dead Not Buried, and afterward also as The Hay Poisoner, he set out at length the grounds upon which he held the trial to have been unfair and the verdict unsafe. He urged that the admission of the Martin evidence had prejudiced the accused beyond what justice allowed, that the case as to the death of Katharine Armstrong was weaker than the verdict implied, and that there was a real possibility, never disproved, that the poison had been taken by the deceased herself, a woman who had suffered disorder of the mind, and who had at hand, in her own house, the arsenical weed killer kept there. This account sets out that argument as the argument of a later writer advanced upon examination of the record, and it does not adopt the suggestion of self-administration as a fact. For a fact it is not, but records it as it stands, a possibility raised and not foreclosed. A later and more measured examination was made by the writer Stephen Bates in a book issued under the title The Poisonous Solicitor. He returned to the whole of the record and weighed it again, and he did not arrive at any clean exoneration of the condemned man, being sceptical of the case for his innocence. But he was critical, as others have been, of the fairness of the trial and of the conduct of the judge, and he found in the proceedings matters that trouble the confidence a verdict of murder ought to command. Between the advocacy of the one writer and the caution of the other lies the settled position of the case in the present day. There has been no exoneration. The conviction stands in law as it was entered, yet the safety of the verdict remains genuinely and seriously in question, a live controversy among those who study such matters, and not a settled thing. At the centre of that controversy, and too often lost within it, is the woman whose death the case concerns. The dispute has fixed itself from the first upon the husband, upon the question of his guilt or his innocence, upon the conduct of his trial and the manner of his death. The woman who died at Mayfield in February of 1921 has tended to recede behind the figure of the man who was hanged for her murder, so that the case famous throughout the country as the case of the Hay poisoner is remembered as his case, and not as hers. This account has held to her so far as the record permits, though the record, as was said at the outset, is thin as to her own life, and full only as to the proceedings that followed her death. Her suffering in her last illness, her removal to the institution, and her recovery there, her return and her decline, her death at 48 in the house she had ordered and kept. These are the facts that belong to her, and they are the facts with which this account has been chiefly concerned. The persistence of the case in the memory of the country has rested upon several supports. There is the standard compilation of the trial, issued in the series of notable British trials, under the editorship of Filson Young in the years after the execution, which preserved the proceedings and made them available to the study of lawyers and of the general reader alike. There are the two modern books already named, the one urging the injustice of the conviction and the other weighing it anew, which revived the case in the closing years of the last century and the opening years of this one, and carried it to a fresh generation of readers. The case has been treated besides, in broadcast and in the general literature, of English poisoning cases, and it has been examined upon the podcast that in recent years have taken up the older crimes. This account names these works as the chief supports of the case's survival, and it does not extend into a catalogue of the lesser ones. Beyond its hold upon the general memory, the case occupies a fixed place in the study of the law itself. The ruling of Mr. Justice Darling upon the admission of the Martin evidence became, and has remained, a leading authority upon the question of similar fact evidence, the question of when the proof of separate acts may be laid before a jury to establish system and to rebut the defence of accident or innocent explanation. Generations of students of the law have studied the Armstrong case for that ruling, and it is taught still in the examination of the principles by which such evidence is admitted or excluded. It is one of the ironies of the case that a matter so debated for its justice should have become so settled a fixture in the teaching of the law, and that the same ruling held by some to have decided the case unfairly should be studied as a landmark of the very principles by which fairness in the admission of evidence is measured. The case belongs to a particular moment in the life of England and Wales, and something of that moment must be set down if the events at Cusop and Hay are to be understood in their setting. The year of Katharine Armstrong's death and the year of her husband's trial fell in the immediate wake of the Great War, in a country still ordering itself anew after the long convulsion. The men who had served had come home to the towns and villages they had left, and they had brought their ranks home with them, so that the roll of a small country town carried its captains and its majors among the ordinary designations of trade and profession. To be addressed by a military rank held in the war was no affectation but the common usage of the day, and the title of Major, borne by the solicitor of Hay, placed him precisely among the respected men of his kind, the demobilised officers of the professional middle class who had resumed the settled occupations of peace. It was a society in which the older deference had been shaken by the war without being wholly overthrown. The professional man still stood near the head of the small community's order. The solicitor and the doctor and the clergyman, the settled figures to whom the district looked, and the respectability that attached to such men was a thing of substance, a standing that governed how they were seen and how far they were trusted. In a town the size of Hay, the professional men were few, and they were known to one another and to all the town, their affairs conducted within a compass so small that the chemist, the doctor, and the rival solicitors were neighbours who met daily in the same narrow streets. The intimacy of such a community is a part of the case, for it was within that intimacy, among men who knew one another well, that the suspicion arose and the proof was gathered. The doctor and the younger solicitor comparing what they knew, the chemist recalling a sale made across his own counter. There is a further feature of the age without which the case cannot be understood, and it is the place that arsenic held in the ordinary life of a household. In the England and Wales of that time, arsenic was a common domestic article, kept and used for common domestic purposes, the destruction of vermin and the killing of weeds chief among them. The weed killer compounded of arsenic was a familiar preparation, sold and bought for the maintenance of a lawn or a garden path, and the purchase of it excited no remark. The law required that the sale of such poisons be entered in a register kept for the purpose, and that the purchaser be known to the seller. But within those requirements, the article passed freely across the counters of the chemists' shops, an ordinary purchase for an ordinary use. It is this circumstance that gave to the defence of the weed killer its whole plausibility, for a man who bought arsenic to destroy the dandelions upon his lawn did nothing that thousands of householders did not do, and the purchase in itself was as innocent as the season's gardening. The whole difficulty of the case for those who tried it and for those who have debated it since lay in the passage from that innocent commonplace to the fatal quantity found in the body of the woman who had died, and in what was to be made of the arsenic that had been divided into doses and could not be explained. The district in which these events fell was itself a place apart, a border country where England and Wales meet along the valley of the Wye. The small town of Hay sat upon the Welsh bank, a market town for the farms of the uplands around it, its trade the trade of livestock and provision, its streets close and old, its society ordered, as the society of such towns was ordered. Across the water, in the English parish of Cusop, the land was more scattered, houses set among fields and woods upon the rising ground toward the Black Mountains, and it was here, in the wooded hollow of the dingle, that the house of the Armstrong family stood. The nearness of the two places, and their division by a border that was at once a line between counties and a line between nations, is a fact the case turns upon at every stage. The home in one country and the profession in the other, the sick room in England and the chemist's shop in Wales, the whole of the matter played out across a few hundred yards of ground and a small river running between. Within that setting, the establishment at Mayfield had stood for years as the ordered home of a professional family, kept to the standard that the family's place required, with servants to maintain it and the observances of a proper household kept up within it. The mistress of that house had governed it by the strict rule that the town remembered, the rule of a woman who forbade wine at her table and kept her house to the pattern of her own principle, and the master of it had gone daily across the border to the town, where he practised the law and served the magistrates. It was an establishment that presented to the district every appearance of settled respectability, and it was from within that appearance, without warning and without suspicion at the time, that the illness came upon its mistress and carried her, through the long months of sickness and recovery and relapse, to her death. The materials from which the case may be studied have survived in unusual fullness, as the materials of a great cause of the day were likely to survive. The record of the assize trial was preserved, and the holdings of the National Archive retain the papers of the case. The compilation issued in the series of notable British trials set down the proceedings in a permanent form, and the press of the day, which had followed the matter through every stage from the first suspicion to the carrying out of the sentence, left behind it a vast body of report and commentary, so that the case may be reconstructed in a detail that few cases of its age afford. It is one of the reasons that the debate over the verdict has been able to continue with such vigour, that the record is full enough to be argued over, that the evidence given at the trial and the rulings made upon it may be examined and re-examined by those who come to the case fresh. For a time after the execution, the case held its place in the front of the public memory, one of the celebrated poisoning cases of its century, the case of the respectable professional man who had poisoned his wife and been hanged for it. As the years passed, it receded, as such cases do, from the front of the general memory toward the keeping of the specialists, the lawyers who studied the ruling upon evidence, and the students of criminal history who compiled the great cases of the age. It was revived toward the close of the last century by the book that urged the injustice of the conviction, and again in this century by the book that weighed the case anew, so that the name of the Hay poisoner, which had begun to fade, was carried again to a general readership, and the old questions reopened. Yet through all of it, the fame and the fading and the revival, the memory of the country has fixed upon the man who was tried and hanged, and the woman at the centre of the case, the woman whose death it was, has remained the figure least regarded in the account of her own murder. The case of Katharine Mary Armstrong was entered into the historical record. It has remained there. The verdict stood. The case became part of British memory. That is where the record of the first case ends. We turn now to a second story, quieter than the first and far less remembered, one that unfolded a little earlier and many miles from that ground, in a small Welsh market town where the households were close and the talk of the town travelled quickly. It turned in the end upon the same question the first case left open, the question of what can be proven and what can only be suspected, and the difference between the two. The case of Mabel Greenwood begins in Cydweli, Carmarthenshire, in the south of Wales, in the early summer of 1919. Cydweli at that time was a small and ancient town on the estuary of the river Gwendraeth, a place of a few thousand inhabitants set among the low hills and tidal flats of the Carmarthenshire coast. The town was old, older by centuries than the events described here, and its principal landmark was the Norman castle that stood above the river, a ruin by 1919, but still the defining feature of the place. Below the castle lay the streets of the town proper, a parish church, a town hall, shops and public houses, and the houses of the more comfortable families of the district, of which Rumsey House was one. The Wales of 1919 was not the Wales of the Victorian age, though the two were separated by only a generation. The Great War had ended the previous November, and the country to which the surviving men returned had been altered by 4 years of it. The coal and tin and iron of industrial South Wales lay a short distance to the east and south, in the valleys and along the coast toward Llanelli and Swansea, and Cydweli itself had its own small industrial history in tin plate and brick. But the town in these years was chiefly a quiet one, agricultural and domestic in its rhythms, a place where the professional and propertied families were known to everyone and observed by everyone, and where the daily comings and goings of a solicitor or a doctor were a matter of common knowledge. It was a settled community, in the sense that families remained in it across generations, and that reputation, once formed, was durable. The town possessed the ordinary institutions of Edwardian and post-war provincial life, the parish and its churchyard at St Mary's, the chapels of the several nonconformist congregations, the market, the constabulary of the county, and the town hall where public business was conducted. The corrected sentence, it was the kind of place in which a household kept servants who saw much of what passed within its walls, and in which those servants, the tradesmen who called, and the neighbours who watched from their windows, together formed a record of a family's private life, more complete than the family itself might have wished. This is a matter of some importance to what follows, for the case of Mabel Greenwood was driven, in its earliest stages, not by any evidence but by the talk of the town. Into this setting Mabel Greenwood had come as the wife of a solicitor, and in it she had lived for a number of years before the events of 1919. She was, by the accounts that survive, a woman in her 40s at the time of her death, though the sources do not agree upon a precise figure, and none is set down here with certainty. She was remembered in Kidwelly as a kind and quietly generous woman, well liked in the town, and the impression the record leaves is of a settled and unremarkable domestic life, a wife and mother in a comfortable house, whose days were passed within the small compass of the town and its society. The household at Rumsey House was sustained, in its material comforts, by Mabel Greenwood's own means. It was her money that had built the manner of life the family enjoyed, her income that maintained the house, the servants, and the standing of the family in the town. This is a documented feature of the case, and it bears upon what came after for the man she had married, an English-born solicitor practising some miles away in Llanelly, was in his own affairs a good deal less prosperous than his manner and his position suggested. The comforts of Rumsey House were, in substance, hers. Of Mabel Greenwood's family of origin, the record preserves little that can be stated with confidence. Her maiden name is given in some accounts as Bowater, though this cannot be asserted without qualification, and the particulars of her parents, their names and their circumstances, do not survive in any form that permits them to be set down here. What can be said is that she brought means to the marriage, that those means were her own, and that they were the foundation upon which the household stood. Beyond this, the early life of Mabel Greenwood is a matter upon which the record is largely silent, and it is not the practice of this account to fill such silences with invention. The marriage itself had produced several children, among them a daughter named Irene, who by the years of 1919 and 1920 had grown into a young woman, and who would come, in the course of events, to play a decisive part in the case. To the outward view, the marriage was a comfortable one, the marriage of a solicitor and his wife, in a good house in a small town, attended by the ordinary appearances of respectability. Within it, by the accounts that later circulated, matters were colder than the appearance suggested. It was said in the town, though it must be understood as the talk of the town and not as established fact, that the attention of the husband had wandered, and that the marriage was one of outward comforts and inward distance. Such talk is recorded here only because it became, in time, part of the machinery that set the investigation in motion. The house in which this life was passed, Rumsey House, was a substantial residence in Kidwelly, a house with grounds and a garden and a complement of servants. It is the garden, and one ordinary feature of it, that must be marked at the outset, for it would become central to everything that followed. In the garden of Rumsey House, as in the gardens of many such houses of the period, weed killer was used, and the weed killer of that time commonly contained arsenic. This was in no way remarkable. Arsenical weed killer was an ordinary domestic article in the gardens of the day, kept in sheds and outhouses across the country, and its presence at Rumsey House was the presence of a thing to be found at 1,000 other such houses. That it should later become the hinge of a trial for murder was a consequence not of anything unusual in its being there, but of the use to which the fact of its being there was afterward put. Harold Greenwood, the husband, was an English-born solicitor who practised in Llanelli, a larger industrial town some miles from Kidwelly along the coast. Each working day carried him from the quiet of Kidwelly to his practice in Llanelli, and returned him in the evening, the ordinary commute of a professional man of the district. His practice, however, did not prosper in the measure that his position implied, and his personal finances were, by the evidence that later emerged, dependent in large part upon his wife's money. This dependence is a documented fact of the case. It must not, however, be permitted to harden into something it is not. The prosecution would in due course present it as motive, and the jury would in due course reject the conclusion the prosecution drew from it. It is set down here as a fact of the household's economy, and nothing more, for no court ever established that it was the spring of any crime. The events with which the case is properly concerned belong to a single weekend in June of 1919, and to the weeks and months that followed. On Sunday the 15th of June, the household at Rumsey House sat down together to their midday meal, as such households did. The particulars of that meal became, in time, among the most closely examined facts in the whole of the case, for it was around the table on that Sunday that the events which ended in a trial for murder were said to have begun. The family ate together, and there was wine upon the table, and it is upon the wine that the later allegations turned. Mabel Greenwood drank Burgundy at that Sunday meal. The others of the household did not, or did not drink of the same wine, and this circumstance, that she alone had taken the Burgundy, would afterward be made the foundation of the theory that the Burgundy had been the vehicle by which poison was conveyed to her. That afternoon, in the hours following the meal, Mabel Greenwood was taken violently ill. She suffered sickness and pain, the symptoms coming upon her through the afternoon and into the evening, and her condition did not improve as the day wore on. The local doctor was summoned to attend her, and through the night of the 15th into the 16th of June, he was in attendance at Rumsey House. She did not recover. In the early hours of the 16th of June 1919, Mabel Greenwood died at Rumsey House in the presence of the physician who had attended her through the night. The doctor certified the cause of her death as valvular disease of the heart, a natural cause, a failure of the heart of the kind that carried off many people of middle age in that period without exciting the least suspicion. Upon that certificate, her death was recorded as a death by natural causes, and there the matter, in the ordinary course of things, would have ended. She was buried in the churchyard of St Mary's at Kidwelly, in the town where she had lived, and the household at Rumsey House was left to its mourning. The certificate of valvular disease of the heart was not, it must be said plainly, an unreasonable one. The symptoms of the final illness, the suddenness of the collapse, the age of the patient, all of these were consistent with the diagnosis the doctor recorded, and the reasonableness of that original diagnosis would afterward become one of the central pillars upon which the defence was built. A physician attending a woman in her 40s who was seized with sickness and pain and who died within a day might well in 1919, and without any negligence whatever, set down the cause as a failure of the heart. That is what the local doctor did, and the death of Mabel Greenwood passed for a time into the record as a natural one. For a time it did end there. The household mourned, the town observed its mourning, and the ordinary business of the place resumed. But within a short span of months, an event occurred that reopened everything, and it did so not by any new medical finding, nor by any confession, nor by the discovery of any fresh fact, but simply by its own social force. Within 4 months of the death of his wife, Harold Greenwood remarried. His second wife was a woman named Gladys Jones, considerably younger than himself, and the marriage followed so closely upon the burial at St Mary's that it became, in a town already disposed to talk, the single fact around which all the talk now gathered. It is necessary to set this down carefully, for it is the social hinge upon which the whole of the case afterward turned, and it is easily misunderstood. The remarriage of Harold Greenwood proved nothing. A widower may remarry within months of a bereavement for reasons that have nothing whatever to do with the manner of the first wife's death, and many have done so without the least impropriety. But in Kidwelly, in the autumn of 1919, in a small and observant town where the coldness of the first marriage had already been the subject of comment, the speed of the second marriage was not received as a private matter. It was received as a provocation, and it hardened the loose talk of the town into a settled conviction that something was wrong, and that the death of Mabel Greenwood ought never to have been let pass as a natural one. The talk spread and grew. It moved through the households and the public houses and the shops of Kidwelly, and it acquired, as such talk does, a momentum that no individual had given it, and that no individual could now arrest. The comfortable death certificate of the previous June, the certificate of valvular disease of the heart, came to be spoken of as too convenient, and the sudden illness at the Sunday meal, the burgundy that the dead woman alone had drunk, the weed killer in the garden shed, and the young second wife installed at Rumsey House, within the season, were assembled by the town, out of its own suspicion, and without any medical or legal authority whatever, into the shape of an accusation. It was this pressure, the pressure of a community's collective suspicion, and not any evidence in the possession of the authorities, that at length compelled an investigation. Under the weight of that public feeling, the police of the county acted. The matter could not be permitted to rest upon rumour, and the only means by which the rumour could be either confirmed or dispelled lay in the body that had been buried at St Mary's in June. An application was made, and authority was obtained for the exhumation of the remains of Mabel Greenwood. The investigation was formally opened, and it proceeded upon the single question that the town had forced into the open: whether the woman certified to have died of a diseased heart had in truth died of something else. On the 16th of April 1920, 10 months after her burial, the body of Mabel Greenwood was exhumed from the churchyard of St Mary's at Kidwelly. The exhumation was conducted under the authority of the proper officers, in the presence of those whose duty it was to attend, and the remains were removed for examination. An exhumation of this kind was not a common event in the life of a small Welsh town, and its taking place at all was itself a public confirmation that the death was no longer regarded as a settled matter. Whatever the examination should find, the fact of the exhumation had already made the case a public one, and the eyes of more than Kidwelly were now upon it. The examination of the remains produced two findings, and it is upon these two findings, and upon the contest between them, that the medical dimension of the entire case would rest. The first was that the examination disclosed no disease of the heart. The valvular disease that had been certified as the cause of death in June of 1990 was not found upon examination in April of 1920. The natural cause that had been recorded upon the certificate, and upon which the burial had proceeded, was, upon this examination, not supported. The second finding was that arsenic was present in the remains. The quantity recovered was small, and it is given in the accounts of the case as lying between 1/4 and 1/2 of a grain. This was the whole of the physical foundation of what would become a trial for murder. No disease of the heart where a disease of the heart had been certified, and a small quantity of arsenic present in the body of a woman who had died within a day of a sudden and violent illness. Upon these two facts the prosecution would be built, and against the sufficiency of these two facts the defence would be directed. The smallness of the quantity, and the fact that it fell within so narrow a range, were not incidental details. They would be made to bear a great deal of weight on both sides of the case. To the prosecution, the arsenic was arsenic, present where it had no business to be, in a body whose certified cause of death had just been shown to be false. To the defence, the quantity was contestable, its source was contestable, and the very fact that the original and reasonable diagnosis of heart disease had been made by an attending physician was itself a point to be pressed. The medical findings, in short, did not close the question. They opened it, and they opened it in a form that could be argued either way. Upon these findings, the investigation proceeded to its conclusion. Statements were taken from those who had been present in the household, from the servants who had attended upon the family, from the tradesmen and the neighbours whose observations had fed the talk of the town, and from the medical men concerned in both the original certification and the later examination. The garden of Rumsey House and its stores were examined, and the presence there of arsenical weed killer was established as a fact, though a fact, it must be repeated, of an entirely ordinary kind. The daily movements of the household on the 15th and 16th of June, the ordering and serving of the Sunday meal and the particular matter of the burgundy were reconstructed as closely as the recollection of witnesses 10 months after the events permitted. At the close of the investigation, the county's officers had assembled a case that was wholly circumstantial. There was no witness to the administration of any poison. There was no confession. There was no direct evidence that any hand had introduced arsenic into the burgundy or into anything else that Mabel Greenwood had taken. There was a body without the certified heart disease, a small quantity of arsenic within it, a household in which arsenical weed killer was kept, a wife whose money had maintained her husband, and a husband who had married a younger woman within 4 months of her death. Out of these materials, and out of the pressure of the town, the machinery of the law was now set in motion against Harold Greenwood, who was arrested and charged with the murder of his wife. Before the matter could come to trial at the assizes, it was brought first before a coroner's inquest, and the inquest into the death of Mabel Greenwood was convened at the town hall of Kidwelly in June of 1920, a year almost to the day after she had died. The inquest was the older of the two proceedings in its form, a public inquiry before the coroner and a jury of the district into the cause and circumstances of a death, and in a case such as this it served as the first formal testing of the evidence that the investigation had gathered. The town that had forced the exhumation now filled the town hall to hear the evidence examined in the open. Before the coroner, the medical findings were laid out, the absence of the certified heart disease and the presence of the arsenic, and the witnesses who had been examined in the course of the investigation gave their accounts of the household and of the Sunday meal and of the events that had followed it. The inquest heard the evidence of the physicians, the evidence of the servants and members of the household, and the evidence bearing upon the arrangement of the fatal meal and the wine that had been drunk at it. The proceeding occupied the attention of the town and of a growing readership beyond it, for the newspapers had by now taken up the case and carried its details to a national audience. At the conclusion of the evidence, the coroner's jury returned its verdict. The jury found that Mabel Greenwood had died of arsenical poisoning, and it found further that the poison had been administered by her husband. Upon that verdict, Harold Greenwood was committed for trial upon the charge of murder. It is necessary to record this inquest verdict as the documented fact that it is a unanimous finding of murder by poisoning at the hand of the husband, and it is necessary in the same breath to record that this verdict was not the end of the matter and did not settle it. An inquest verdict was a finding of the coroner's jury upon the evidence before it. It committed a man for trial. It did not convict him, and the trial that followed would return a different answer. The trial of Harold Greenwood commenced at the Carmarthen Assizes in November of 1920. The Assizes were the higher criminal court of the county, at which the graver charges were tried before a judge sent out upon circuit and a jury empanelled for the purpose, and the trial of a solicitor for the murder of his wife by poison was a matter of the first magnitude in the life of Carmarthenshire. The town of Carmarthen filled for it. The newspapers of Wales and of London sent their reporters, and the case that had begun as the talk of a single small town was now followed across the country. Its evidence set out column by column for a readership that had made of it one of the sensations of the year. The charge was the wilful murder of Mabel Greenwood by the administration of arsenic. To that charge Harold Greenwood pleaded not guilty. The defence of a man in his position, upon a capital charge, was a matter of the gravest consequence, for a conviction for murder carried with it the sentence of death, and there was in that period no discretion in the pronouncement of it. The man in the dock therefore stood in peril of his life upon the evidence that the county had assembled, and the conduct of his defence was placed in the hands of the most celebrated advocate, then practising at the English bar. The defence of Harold Greenwood was led by Sir Edward Marshall Hall, a King's Counsel, whose name was by 1920 known far beyond the profession of the law. He was the foremost defender of his generation, a barrister whose reputation had been built upon precisely such cases as this, cases in which a life hung upon circumstantial evidence and upon the capacity of an advocate to raise, in the minds of a jury, a doubt that the prosecution could not dispel. The retaining of Marshall Hall was itself a signal of the seriousness of the case, and his presence at Carmarthen drew to the assizes an attention that the case might not otherwise have commanded. The prosecution was conducted by senior Crown Counsel upon the circuit, and the case for the Crown was laid before Mr. Justice Shearman and the jury in the ordinary form. The case for the Crown was the case that the investigation and the inquest had built. It was contended that Mabel Greenwood had not died of the heart disease certified in June of 1919, that arsenic had been found in her remains upon the exhumation, and that the arsenic had been administered to her in the burgundy she alone had drunk at the Sunday meal on the 15th of June. To this was joined the matter of the household's economy, the dependence of the husband upon the wife's money, and the matter of the remarriage within 4 months of the death. From these, the prosecution invited the jury to conclude that Harold Greenwood had poisoned his wife, and had done so for the reasons that the arrangement of his life suggested. Against this, the defence directed itself upon 3 principal lines, and each of them was aimed not at proving the innocence of the accused, which the law did not require, but at showing that the case for the Crown fell short of the certainty that a capital conviction demanded. The first line concerned the source of the arsenic. It was pressed upon the jury that arsenic was present at Rumsey House in an entirely lawful and ordinary form, in the weed killer used in the garden, and that the presence of a small quantity of arsenic in the remains was therefore consistent with sources other than deliberate poisoning. The weed killer in the garden shed, an article to be found at countless houses of the district, was set before the jury as an innocent explanation for the very substance upon which the whole of the prosecution rested. The second line concerned the original diagnosis. The defence pressed that the certification of valvular disease of the heart by the attending physician in June of 1919 had been a reasonable one, made in good faith by a competent man upon the symptoms before him, and consistent with the sudden illness and rapid death of a woman of Mabel Greenwood's age. If the original diagnosis had been reasonable, then the death had worn, at the time, every appearance of a natural one, and the later finding of arsenic did not of itself convert a reasonable, natural death into a proven murder. The equivocal character of the medical evidence, the small and contestable quantity of arsenic set against a diagnosis that had been proper when it was made, was pressed upon the jury as a doubt that the Crown could not remove. The third line was the most direct, and it was the one upon which the trial is chiefly remembered. The prosecution's theory required that the poison had been conveyed in the burgundy, for it was the burgundy that Mabel Greenwood alone had drunk, and it was the singularity of her having drunk it that made the wine the vehicle of the alleged crime. Against this, Marshall Hall called into the witness box the daughter of the household, Irene Greenwood, a grown young woman by the time of the trial, and the daughter of the dead woman and of the man who stood accused of killing her. Irene Greenwood testified that she too had drunk from the same bottle of burgundy. She had taken wine from the very bottle that the prosecution said had carried the poison to her mother, and she had suffered no harm from it. This single piece of evidence struck at the foundation of the prosecution's theory, for if the bottle of Burgundy had been poisoned, then the daughter who had drunk from it should have been affected, as the mother had been, and she had not been. The theory that the wine was the vehicle could not easily survive the fact that another person had drunk of the same wine and taken no hurt. The evidence of the daughter, given for the defence of her father, upon a charge of murdering her mother, was the decisive stroke of the trial, and it collapsed the case that the Burgundy had been the instrument of death. The evidence being closed and the arguments of counsel concluded, Mr. Justice Shearman delivered his charge to the jury, setting before them the evidence they had heard and the law by which they were to be governed. The jury were reminded that the burden lay upon the Crown, that the case against the accused was a case of circumstance, and that they were not to convict unless the evidence satisfied them of guilt beyond reasonable doubt. Upon that direction, the jury of Carmarthenshire retired to consider whether Harold Greenwood had murdered his wife. The jury retired, and in due course they returned. On the 9th of November 1920, the jury returned a verdict of not guilty. Harold Greenwood was acquitted of the murder of his wife. Upon that verdict he was discharged, a free man, no longer in peril of the sentence of death that a contrary verdict must have carried, and the trial that had held the attention of the country came to its end in an acquittal. But the verdict of the jury was not, on this occasion, the whole of what the jury had to say, and the case is distinguished among the poisoning trials of its age by what accompanied the acquittal. The jury attached to their verdict a rider, a statement of the sense in which they had reached it, and the rider was of a most unusual character. The jury stated in substance that they were satisfied that a dangerous dose of arsenic had been given to Mabel Greenwood. They were satisfied, that is to say, that poison had been administered. What they were not satisfied of was that the arsenic had caused her death, nor by what means it had been administered, nor by whose hand. Upon those questions the evidence had not carried them to the certainty that a conviction required, and it was upon that failure of proof, and not upon any finding that no poison had been given, that the acquittal rested. The rider was not made public at the time, and its existence became generally known only afterward, but it stands in the record as the truest measure of what the trial had and had not established. It found, on the one hand, that a dangerous dose of arsenic had been given. It found, on the other, that the Crown had not proved that this dose had killed her, nor how it had reached her, nor who had administered it. Between those two findings lies the whole of the unresolved question of the death of Mabel Greenwood, and no proceeding, after the trial, ever closed the gap between them. No sentence followed the verdict, for the man had been acquitted, and the court that would have proceeded to sentencing upon a conviction had no such office to perform. Harold Greenwood left the Carmarthen assizes a free man, cleared in law of the charge that had been brought against him, and entitled in law to be regarded as innocent of it. The proceedings that had begun with the talk of a town, and had passed through exhumation, examination, inquest and trial, had ended in the only verdict that the law recognised as final, and that verdict was one of acquittal. In the strict account of the law, the matter was closed, and closed in his favour. The trial itself passed at once into the annals of the English bar as one of the celebrated defences of its age. The acquittal was received as a triumph of advocacy, and the conduct of the defence, and in particular the calling of the daughter to testify that she too had drunk of the Burgundy, was studied and recounted for long afterward as an example of the art by which a capital charge upon circumstantial evidence might be met and defeated. The case took its place among the great trials of the period and among the celebrated causes of the advocate who had led the defence, and it is chiefly through that channel, the literature of famous trials and of famous advocates, that the name of Mabel Greenwood has survived at all beyond the county in which she died. But the acquittal, complete as it was in law, did not restore to Harold Greenwood the life he had led before it. the verdict cleared him of the charge. It did not clear him in the estimation of the public that had followed the case, nor in the estimation of the district in which he had lived and practised. The suspicion that the town had assembled before the trial was not dissolved by the verdict at the trial, and the rider that the jury had attached to their acquittal, once it became known, gave to that suspicion a kind of a standing that a plain acquittal would not have left it. A man of whom a jury had said, in acquitting him, that a dangerous dose of arsenic had none the less been given to his wife, was not a man whom his neighbours could regard as they had regarded him before. The consequence was the ruin of his professional and public life. His practice as a solicitor in Llanelli did not survive the case. The standing he had held in the district was gone, and the ordinary conduct of a professional life among people who knew him and had followed the trial became impossible. Here the case presents one of its most documented and most sober features, the spectacle of a man acquitted by a court of law and yet destroyed by the proceedings that had ended in his acquittal. The verdict had saved his life. It had not saved his living, nor his name, nor his place among the people of Carmarthenshire, and in every practical respect the life he had built at Kidwelly and Llanelli was at an end. He did not remain to endure it. Harold Greenwood withdrew from the district, and he passed the remainder of his years quietly and out of public view, living under another name. The man who'd been the central figure of one of the sensations of 1920 sought, in the years that followed, only to be forgotten, and to a large degree he succeeded, for the later course of his life is recorded only in its barest outline. He died in 1929, some 9 years after the trial that had acquitted him and unmade him, having lived out those years, apart from the place and the name by which the case had known him. Mabel Greenwood remained where she had been laid, in the churchyard of St Mary's at Kidwelly, in the town where she had lived and died. The case that survived them both was and has remained an unresolved one, and it is important to state the exact character of that lack of resolution, for it is not the ordinary lack of resolution of an unsolved crime. This was not a case in which a body was found and no perpetrator identified. It was a case in which it was never established, and has never since been established, that a crime was committed at all. The central question of the death of Mabel Greenwood is not who poisoned her. It is whether she was poisoned to death by any hand, or whether she died of causes that the equivocal medical evidence could neither confirm nor exclude. That question the inquest answered one way, and the trial answered another, and between the coroner's verdict of murder and the assize verdict of acquittal, the truth of the matter was never fixed. The medical evidence upon which everything turned could not resolve it. The certified heart disease had not been found. The arsenic had been found, but in a quantity small and contestable, and its mere presence did not establish that it had been the cause of death, still less that it had been deliberately given. The jury who acquitted had been satisfied that a dangerous dose had been administered, and yet unpersuaded that it had killed her, or by what means it had reached her. Every one of the natural means by which such a question might be closed, a confession, a witness to the act, an unequivocal cause of death, was absent, and no later inquiry supplied any of them. The case therefore stands not as a solved crime, nor as an unsolved one in the usual sense, but as a death whose very nature remained in doubt. Around the matter of the arsenic and its source, the argument has never entirely ceased. The weed killer in the garden shed, which the defence had raised as an innocent explanation, remained a possibility that could be neither proved nor dismissed. The small quantity recovered upon the exhumation, lying somewhere between 1/4 of a grain, was consistent with more than one account of how it had come to be there, and the passage of 10 months between the burial and the exhumation was itself a circumstance that complicated the reading of the remains. The science of 1920, brought to bear upon a body long buried, could describe what it found, but could not always say with certainty how what it found had come to be. In this, the case belonged to a class of poisoning trials of its era, in which the medical evidence, however carefully given, left the essential question open. In the literature that has preserved the case, it is most often set beside another and closely contemporaneous matter, a second trial of a solicitor upon a charge of poisoning, and the two are frequently recounted together as instances of a particular kind of case that occupied the courts and the newspapers of those years. That pairing has carried the name of Greenwood forward alongside a case better remembered than her own, and it is largely as one half of such a pairing, and as a chapter in the record of a famous advocate, that the death at Kidwelly has kept its small place in the memory of British crime. The standard accounts, the biographies of the defending counsel, the anthologies of great trials, and the later summaries drawn from them, form the body of writing through which the case is now known, and they are, for the most part, accounts of the trial rather than of the woman who died. That is a feature of the case worth marking without embellishment. The proceedings preserved the name of Mabel Greenwood, but they preserved it as the name attached to a question and to a celebrated acquittal, rather than as the record of a life. Of the woman herself, the kind and quietly generous figure whose money had built the household at Rumsey House, the record retains comparatively little, and what it retains is set down in the language of witnesses recalling, a year afterward, the events of a single weekend in June. The fuller life she had led in Kidwelly before that weekend passed largely unrecorded, as the lives of such women commonly did, and the documentation that survives is the documentation of her death and of the trial it produced, rather than of the years that preceded either. The historical legacy of the case lies in that very tension between an acquittal in law and a suspicion that the acquittal did not extinguish, and it is for this that the death at Kidwelly has been cited in the years since as more than a local curiosity. It is remembered in Carmarthenshire as an event in the life of the town, one of those matters that a small place carries in its collective memory across generations, and it is remembered more widely as a study in the difficulties of the circumstantial poisoning case, in which the science of the day could establish the presence of a poison, but not always the fact or the manner of its administration. The two verdicts it produced, the coroner's and the assizes, stand together in the record as an illustration of how differently the same body of evidence might be weighed by two juries under two different burdens of proof. It has been cited, too, as a cautionary instance of the power of common talk to set the machinery of the law in motion. The investigation into the death of Mabel Greenwood was not begun upon evidence. It was begun upon suspicion, upon the suspicion of a town that had watched a hasty remarriage and drawn its own conclusions, and the exhumation and the analysis and the inquest and the trial all followed from that suspicion, rather than from any discovery that had preceded it. That a death certified as natural and buried as natural could be reopened, examined, and brought to a capital trial upon the strength of what a community believed, rather than upon what any officer had found, is a feature of the case that later accounts have not failed to mark. The talk did not prove its own conclusion. It proved powerful enough to compel a full inquiry into whether that conclusion was true, and the inquiry, when it came, could not confirm it beyond doubt. The social setting in which all of this occurred was the post-war Wales of 1919 and 1920, and it is worth setting down plainly that this was not the Wales of an earlier and more settled century. The Great War had closed only months before Mabel Greenwood's death, and the country was in that unsettled aftermath in which the losses of the war and the changes it had brought were still being reckoned with. Small towns such as Kidwelly had sent their men to it and had received back those who returned, and the ordinary life of the district was resuming its shape after 4 years in which that shape had been disturbed. It was into this recovering and watchful society that the case fell, and the intensity with which the town took up the death and pursued it may owe something to the heightened condition of a community only lately emerged from the war. The particular circumstances of the household belong to the ordinary domestic economy of the professional class of such a district. A solicitor with a practice in a nearby industrial town, a wife whose inherited means maintain the establishment, a substantial house with grounds and servants, and a garden in which arsenical weed killer was kept as a matter of course. These were the unremarkable materials of a comfortable provincial life, and it is one of the sober lessons of the case that a capital charge could be constructed out of materials so entirely ordinary. There was nothing in the garden shed of Rumsey House that was not in 1,000 other garden sheds. There was nothing in the arrangement of the household, a professional man dependent upon his wife's money, that was not to be found in many another marriage of the period. The elements that the prosecution assembled into a theory of murder were, taken singly, the common furniture of the age. The atmosphere of the place through which the case moved has left its own faint impression in the record. There is the old town of Kidwelly, with its castle above the estuary and its churchyard at St Mary's, where the burial took place in the June of 1919, and from which the exhumation was made in the April of 1920. There is Rumsey House, with its grounds and its servants and its Sunday table. There is the town hall, where the coroner sat and the county assembled to hear the inquest. And there is Carmarthen and its assize court, filled for the trial, with the reporters of the London and Welsh papers in attendance, and the crowds gathered for the verdict. And there is the daily journey of the solicitor between the quiet of Kidwelly and his practice in the busier town of Llanelly along the coast. The ordinary commute of a professional man, threaded through the whole of the case as the pattern of the life that the trial brought to an end. The exhumation itself remained, for the town, among the most striking of the case's episodes, for it was an event of a kind that the district had rarely, if ever, witnessed. To open a grave in the churchyard of St Mary's 10 months after a burial, to remove the remains of a woman the town had known, and to carry them away for examination, was a public act that gave to the private suspicions of the town a formal and unmistakable expression. From the moment of the exhumation, there could be no returning to the quiet of the natural death certified the year before. The grave had been opened, and whatever the examination should disclose, the disturbance of it had already made the death a matter of record and of inquiry that could not again be closed by a certificate. The trial that followed the exhumation gave to Carmarthenshire, for the space of that November, a place at the centre of the country's attention that it neither sought nor long retained. The details of the Sunday meal, the burgundy, the weed killer, the exhumation and the arsenic, and the presence in the case of the most famous advocate of the day, made of the proceedings a spectacle followed far beyond the borders of the county. For a few weeks the name of a Welsh market town stood in the newspapers of London, and then, with the verdict and the acquittal, the attention that had gathered upon it dispersed, and the case receded from the national view as quickly as it had entered it. What remained in Carmarthenshire after the reporters had gone was a town that had accused one of its own, an inquest and a trial that had answered its accusation with 2 different verdicts, and a grave at St Mary's returned to its quiet. The record that the case left behind is, by the measure of such matters, a substantial one. There survived the file of the proceedings against Harold Greenwood, the record of the assize trial at Carmarthen, the record of the inquest held at the town hall of Kidwelly, and the extensive reporting of the Welsh and national press through the year of 1920. From these, the course of the case can be followed with considerable exactness, from the first illness at the Sunday meal to the verdict at the assizes, and it is from these that the accounts written since have been drawn. What the record does not contain, and never contained, is the answer to the question at the centre of it. The documents establish what was alleged, what was examined, what was said in the witness box, and what the 2 juries found. They do not establish what happened at the Sunday lunch on the 15th of June, 1919, and upon that point they are, and have remained, silent. For the silence is the whole of the matter, and it is a silence that no proceeding filled, and no later inquiry has filled since. An inquest jury found murder. An assize jury found the charge not proven, and attached to their finding the observation that a dangerous dose of arsenic had nonetheless been given. A man was acquitted and was ruined by the acquittal, and lived out his years under another name. A woman lay in the churchyard of St. Mary's, exhumed once and returned, and the cause of her death remained, after all of it, a thing suspected and asserted and denied but never established. The case was as complete in its documentation as any of its kind, and as incomplete in its answer as a case can be. The record was entered. No further legal proceedings followed. The record closed without resolution. That is where the record of the second case ends. We turn now to the last of these three stories, older than the two that came before it, and set far from the quiet country houses of the border. It belongs to a different decade and a different England, to the crowded streets of the capital, rather than the gardens of a market town, and yet it turns upon a question that no verdict has ever fully settled. It is a case of ledgers and rent books rather than chemists and gardens, but the doubt it left behind has proved every bit as durable. The case of Mary Emsley begins in Stepney, in the East End of London, in the summer of 1860. Stepney was then one of the older districts of the metropolis east of the city, a parish of dense terraced streets, small workshops, and the constant movement of casual labour that fed the docks and the trades along the river. The London of 1860 was the largest city in the world, its population well past 2.5 million and still growing, and its eastern parishes absorbed much of that growth into rows of modest brick houses thrown up for the labouring poor. Grove Road, where Mary Emsley lived, was one such street, a run of small terraced dwellings of the plainest kind, built for rent and occupied by families who paid their landlords weekly. The character of the district was working class and industrious, its inhabitants employed in the docks, the building trades, the clothing workshops, and the innumerable small callings that kept a great city supplied. Bethnal Green lay to the north, Bow to the east, and Whitechapel to the west, and across all of them ran the same pattern of narrow streets and closely packed houses, of public houses on the corners, and tradesmen's premises let into the ground floors. Rents were low, wages were irregular, and a great part of the population lived by the week, moving from one lodging to another as work and money allowed. It was a landscape of small properties and small transactions, and it supported a class of landlords who owned not grand estates, but rows of humble houses, let out a few shillings at a time. Into this economy, Mary Emsley had risen to become one of the wealthiest people in the East End of London. She was a widow, then about 70 years of age, and her fortune lay not in any single great possession, but in property of the most modest kind. She owned, by the accounts that survive, well over 100 small houses scattered across Stepney, Bethnal Green, and Bow, terraced dwellings of the same plain sort as those around her own door. She had inherited a portion of this property and had expanded it by careful management over many years, and the income it produced had made her, in the reckoning of her neighbourhood, a woman of very considerable means. Her wealth, however, altered her manner of living scarcely at all. She was frugal to a degree that her neighbours regarded as miserliness, and she conducted her affairs with a plainness that gave no outward sign of the fortune she controlled. She kept no servants. She lived entirely alone at 9 Grove Road, a house no different in appearance from the others in the row, and she managed the whole of her property herself, without the assistance of an agent or a household of dependents. Her independence was complete, and it was of long standing, and it shaped every part of the life that the record preserves. The particulars of her early years, her family of origin, and the circumstances of her first marriage do not survive in any form that permits a confident account, and they need not be supplied by invention. What the record establishes is the shape of her life as it stood in 1860. She was old, she was alone, she was rich in the humble coin of terraced rents, and she was known throughout the eastern parishes as a landlady who attended to her own business and trusted the management of it to no one else. That reputation and the habits that came with it are the ground on which the case is built. If you value cases like this one, drawn from records rather than speculation, subscribe to the channel. Now back to the record. The manner in which Mary Emsley conducted her affairs brought her into regular and direct contact with a wide circle of the men of her district. She did not employ a collector to gather her rents, or at least did not rely upon one alone. She walked her own streets, week by week, and gathered the neighbourhood's takings door to door. A stooped and elderly woman in plain black clothing, carrying with her the small sums that her tenants paid. She was a familiar figure on the pavements of Stepney and Bethnal Green, moving among the houses she owned with her rent book in hand, and the sight of her going about this weekly business was an ordinary part of the district's life. She managed the upkeep of her properties in the same direct fashion. When repairs were required, she hired local tradesmen herself, engaging plasterers, painters, and other workmen from among the men of the neighbourhood, and she negotiated the terms of their labour personally. She was known to haggle over every shilling, to press for the lowest price, and to keep a close and exacting account of what she spent. This habit of dealing directly with the workmen who served her, and of bargaining hard with them, was as characteristic of her as her rent-collecting rounds, and it drew her into constant dealings with a considerable number of local men. Among these men were her tenants, who owed her money, and the tradesmen, who wanted her work. And it was from this wide pool of persons acquainted with her affairs that suspicion would afterwards be drawn. A woman who collected her own rents and hired her own workmen was known to a great many people, and a great many people knew, in turn, that she was old, that she lived alone, and that she handled money. She kept sums in her house in the course of her business, and the fact was not a secret to those who dealt with her. Her independence, which had served her so long, had made her the centre of a web of small obligations and small resentments spread across several parishes. In the ordinary course of things, she was seen about her rounds and at her house in the early days of August 1860, going about her business, as she always had. Her habits were regular, and her neighbours were accustomed to the pattern of her comings and goings, to the movement of her blinds and the opening of her door. It was by these small and familiar signs that her presence was registered on the street, and it would be by their absence that her death was first suspected. The last certain sightings of Mary Emsley belong to the middle of August 1860. She was known to have been alive, and about her affairs in the days immediately before the 13th of that month, and the evidence afterwards gathered placed her death on or about that date. After it, the ordinary signs of her occupation of the house ceased. Her blinds did not move. Her door was not opened. The small evidences by which a neighbourhood registers the life within a house were, at 9 Grove Road, simply absent, and they remained absent day after day. The house itself was of the plainest kind, a small terraced dwelling like its neighbours, and within it Mary Emsley kept not only her living quarters, but the materials of her trade. In one of the upper rooms, she stored rolls of wallpaper, kept for the repair and letting of her many properties, and it was among these that the events of the case would be found to have taken place. The image the record preserves is a domestic and unremarkable one. An old woman, alone in a small house, surrounded by the plain furniture of a frugal life and the working stock of her business, in a street where nothing distinguished her door from any other. For several days in the middle of August, the house at Grove Road stood shut and still. The unmoving blinds were noticed. Those who had dealings with Mary Emsley and those who lived near her remarked that she had not been seen, and that the house gave no sign of the life it should have contained. Concern gathered slowly, as it does over the quiet of a house that ought not to be quiet, And it was this concern, accumulating over the days that followed the 13th of August, that at last brought others to her door and set in motion the discovery of what had occurred within. On the 17th of August 1860, the silence of the house was at last broken into. Those concerned for Mary Emslie made their way to 9 Grove Road. An entry was gained to the premises that had stood shut for so many days. Within, in the upper room, where the rolls of wallpaper were kept, the body of Mary Emslie was found. She had been dead for some days, and the condition of the body was consistent with a death that had occurred on or about the 13th of August, several days before the discovery, exactly as the unmoving blinds had suggested. She had been killed by violence. The injuries were to the head, and they were severe and had been rapidly fatal. The discovery of the body was reported to the police, and officers were dispatched to the scene without delay. The room in which she lay was examined, and the house was searched, and the first facts of the case were established. Mary Emslie had been struck down in her own home, in the upper room among the materials of her trade, and she had lain there undiscovered, while the street outside carried on its ordinary business and remarked only that her blinds had not moved. The manner of her death was at once apparent as murder, and the circumstances pointed from the beginning to a crime committed by someone she had admitted to the house, or who had otherwise obtained access to it. The examination of the premises produced a fact of the first importance. Money remained in the house. Rent money and other sums were found untouched in parts of the dwelling, sums that a thief who had searched the house thoroughly would have been expected to take. Yet certain sums and certain items were missing, and the account of what the house should have contained did not tally with what was found within it. The conclusion drawn from this was that the crime had been one of robbery, but a robbery interrupted or incomplete, or committed by a person who took what he knew of and could carry, and who had access to the house through his dealings with its owner. The absence of any sign of forced entry supported the same conclusion. Mary Emslie had admitted her killer, or her killer had been a person able to come to her door without exciting her alarm. She was a woman who dealt daily with tradesmen and tenants, who opened her door to the men who paid her rent and the men she hired for her repairs, and any one of that wide circle might have come to her house in the ordinary way and been let in without question. The crime bore the character of an act committed by someone within her acquaintance, someone whose presence at her door was unremarkable, and the investigation proceeded from the outset upon that understanding. There was no eyewitness to the crime. No person had seen the blow struck. No person had seen the killer enter or leave, and the case that would afterwards be built rested wholly upon circumstance. From the beginning, therefore, the investigation was a matter of piecing together the movements of those who had dealings with Mary Emslie, of tracing the missing property, and of weighing the accounts that the men of her acquaintance gave of themselves. It was the kind of case in which no single fact declared the guilty party, and in which everything would depend upon the accumulation and interpretation of many separate details. The investigation was formally opened, and the police turned their attention to the circle of men who collected her rents, carried out her repairs, and otherwise came and went about her properties. A reward of £300 was offered for information leading to the discovery of the murderer, a very large sum for the time and place, and its announcement drew a corresponding attention to the case. In a district where a labouring man might earn £1 a week or less, the promise of £300 was an inducement of extraordinary weight, and it would prove to have consequences of its own for the course the investigation took. Suspicion first fell upon a man named Walter M. M was a shoemaker who also collected rents on Mary Emslie's behalf, one of the men who moved among her properties in the management of her affairs, and his connection with her business brought him early to the notice of the police. He was questioned and his circumstances were examined, and for a time the direction of the inquiry lay towards him. Walter M. was an innocent man, and nothing that the investigation ultimately established gave any ground to think otherwise. But in the first uncertain days, the suspicion that attached to him was real, and it shaped the early course of the case. It was at this stage that another man came forward with an account that would place the investigation upon an entirely new footing. James Mullins, a plasterer by trade and a former police officer, one of the workmen whom Mary Emsley had occasionally employed, presented himself to the authorities with information. He claimed to have watched Walter M. conceal a parcel, and he directed the officers to a shed among M.'s premises where, he said, stolen property from the murdered woman's house would be found hidden. His account was precise, and it pointed directly at the man already under suspicion, and it seemed to promise the resolution of the case. The officers acted upon Mullins' information. They went to the place he had described, and they searched it, and they found a parcel exactly where he had said it would be. The parcel contained property connected with Mary Emsley, and its discovery in the location Mullins had named appeared at first to confirm both his account and the guilt of the man he accused. For a moment the case seemed to have been made, and the £300 seemed destined for the man who had guided the police to the hidden evidence. But the details of Mullins' story would not hold together. As the officers examined the circumstances of the discovery and weighed the manner in which Mullins had come by his knowledge, the account he had given began to unravel. The precision with which he had directed them to the parcel, so far from proving his innocent observation of another man's guilt, came to suggest that he had known where the parcel was because he had placed it there himself. The particulars of when and how he claimed to have watched M did not accord with the other facts, and the more closely his story was tested, the less it could be reconciled with the truth. The conclusion the police reached was that James Mullins had planted the parcel himself. He had taken property from the scene of the murder, concealed it among Walter M.'s premises, and then come forward with a fabricated account of having seen M hide it, in order to fasten the crime upon an innocent man and to claim the reward of £300. The frame-up, so far from diverting suspicion, had turned it back upon its author. A man who could lead the police so exactly to hidden property from the murdered woman's house had, by that very exactness, marked himself as the person most likely to have handled it. Walter M. was cleared. The suspicion that had first attached to him fell away as the true character of Mullins' information became apparent, and he passed out of the case as the innocent man he had always been. He returned to the obscurity from which the investigation had briefly drawn him, and nothing in the record gives any ground to implicate him in the death of Mary Emsley. The attempt to make him the murderer had failed, and it had failed in a manner that recoiled entirely upon the man who had made it. James Mullins was arrested and charged with the murder of Mary Emsley. The case against him was, from the first, a case of circumstance. There was no witness to the crime, and there would be no confession. What the prosecution possessed was the planted parcel and the false account that accompanied it, together with such other traces and connections as linked Mullins to the scene and to the stolen property, and upon this foundation of circumstantial evidence, the whole of the case would have to be built. The man who had come forward to claim a reward for solving the murder stood now accused of having committed it. A post-mortem examination of the body was conducted by the examining surgeon, whose findings established the cause of death. Mary Emsley had died of the injuries to her head, injuries inflicted by blows, and severe enough to have caused death rapidly. The surgeon's examination fixed the violent character of the death beyond question and placed the time of it, from the condition of the body, at several days before the discovery, on or about the 13th of August. These findings, plainly stated, supplied the medical foundation of the case. The cause of death was determined, the time of death was estimated, and the fact of murder was established upon competent examination. A coroner's inquest was convened in August 1860 to inquire into the death of Mary Emsley. An inquest was the formal inquiry held before the coroner and a jury into the cause and circumstances of a death that had occurred by violence or in doubtful conditions, and its purpose was to determine how the deceased had come by her end. The surgeon who had examined the body gave his evidence as to the cause of death, and the circumstances of the discovery were laid before the jury, and the inquest proceeded in the ordinary manner of such inquiries to consider the facts that had been gathered. Having heard the evidence, the coroner's jury returned a verdict of wilful murder. The finding established, as a matter of formal record, that Mary Emsley had been unlawfully and deliberately killed, and it committed the question of who had killed her to the further processes of the law. The inquest did not try the accused, and its verdict was not a conviction, but it fixed the character of the death as murder and opened the way to the criminal proceedings that followed. Upon the committal of the magistrates, James Mullins was sent for trial at the Central Criminal Court. The proceedings before the magistrates followed the inquest in the usual course. The evidence gathered by the police was laid before the bench. The case against Mullins was examined, and the magistrates determined that there was sufficient ground to send him for trial upon the charge of murder. He was committed accordingly, and the venue of the trial was the Central Criminal Court, the Old Bailey, before which the grave felonies of the metropolis were heard. The case that had begun with the discovery of an old woman's body in an upstairs room now moved toward the highest criminal tribunal of the city, upon a foundation of evidence that was wholly circumstantial, and that would be contested at every point. The trial of James Mullins for the murder of Mary Emsley commenced at the Central Criminal Court in October 1860. The charge was murder, and to it the prisoner pleaded not guilty. The proceedings drew a considerable attention, for the case had been much discussed in the press since the discovery in August, and the circumstances of the frame-up had given it a character beyond that of an ordinary robbery ending in death. The court was attended, the case was opened by the prosecution, and the whole matter was laid before a jury for their determination upon the evidence. The prosecution's case was, as it had been from the first, entirely circumstantial. There was no witness who had seen the crime committed, and there was no admission by the prisoner. The Crown's case rested upon the accumulation of many separate facts, each of which pointed toward Mullins, and which together were said to establish his guilt beyond reasonable doubt. The foundation of it was his own conduct in coming forward with the false account of Walter M., and the discovery of the planted parcel that his information had produced. From this, the prosecution argued that only the murderer could have possessed the property he had concealed, and only the murderer would have had the motive to fasten the crime upon an innocent man. To this central circumstance, the Crown added the further traces and connections that the investigation had gathered. There were physical items and impressions said to link the prisoner to the scene, fragments and possessions tied to him, and the account of his movements and his conduct in the days surrounding the murder. The precise weight to be given to each of these particulars was a matter for the jury, and the individual items of evidence are the subject of some uncertainty in the surviving record. What is clear is that the prosecution presented not a single decisive proof, but a chain of circumstances, and it invited the jury to find that the chain, taken as a whole, admitted of no innocent explanation. The manner in which Mullins had directed the police to the parcel was pressed by the Crown as the strongest link in that chain. An innocent observer, it was argued, could not have known with such exactness where the stolen property lay unless he had watched it hidden. Yet the account he gave of watching M conceal it did not withstand examination, and if that account was false, then his knowledge of the parcel's location could be explained only by his having placed it there himself, and if he had placed it there, then the property had passed through his hands, and it had come from the house of the murdered woman. Upon this reasoning, the prosecution built the heart of its case. The defence denied the prisoner's involvement in the murder. It sought to keep the suspicion upon others, and to represent the case against Mullins as a construction of circumstance that fell short of the certainty required for a conviction upon a capital charge. Where the Crown saw a chain of facts admitting of no innocent reading, the defence urged that circumstantial evidence, however suggestive, could be mistaken, and that the absence of any witness to the crime left room for doubt. The prisoner maintained his innocence throughout, and his counsel pressed upon the jury the gravity of convicting a man of murder upon inference alone. The evidence was heard over the course of the trial, and the witnesses for the prosecution were examined and cross-examined in the ordinary course. The officers who had conducted the investigation gave their accounts of the discovery of the body, the search of the premises, and the events surrounding the finding of the parcel. The examining surgeon gave evidence of the cause of death. The various persons who could speak to the prisoner's movements and to the property connected with the case were called, and the whole body of circumstance was laid before the court piece by piece in the patient manner of a trial resting upon inference. When the evidence was concluded, counsel addressed the jury, and the judge summed up the case. The jury retired to deliberate upon their verdict. The question before them was whether the circumstances proved against James Mullins established his guilt beyond reasonable doubt, or whether the want of any direct evidence left the matter in doubt. It was a question upon which the case had turned from the beginning, and it was now committed to 12 men to decide, with the life of the prisoner depending upon their answer. The jury returned a verdict of guilty. Upon the evidence of circumstance, and in the absence of any witness to the crime or confession from the prisoner, they found that James Mullins had murdered Mary Emsley. The verdict rested wholly upon the chain of facts the prosecution had assembled, and it represented the jury's conclusion that those facts admitted of no other reasonable explanation than the prisoner's guilt. The finding was entered, and the court proceeded to the passing of sentence. Upon the verdict of the jury, the sentence of the court was death. For the crime of wilful murder, the law admitted of no other penalty, and the sentence was pronounced in the accustomed form. The prisoner, who had maintained his innocence throughout the trial, continued to maintain it after the verdict, and he protested against the justice of the conviction. He declared not only his own innocence, but the innocence of Walter M., the man he had himself sought to accuse, and in this double protestation lay the beginning of the doubt that would attach to the case ever after. The trial and its outcome commanded a wide attention in the press, and the character of the evidence did not pass without comment even at the time. That a man had been condemned to death upon circumstantial evidence alone, in a case where no one had seen the crime committed, was a matter that fed public unease, and the subplot of the attempted frame-up gave the case a further complication. Some who followed the proceedings were satisfied that the chain of circumstance had established the prisoner's guilt. Others were uneasy at a capital conviction resting upon inference, and that unease was recorded alongside the verdict. The interval between sentence and execution was occupied with the ordinary attention that a capital case drew, and with the continued protestations of the condemned man. He did not withdraw his claim of innocence. He did not confess. He maintained to those about him the account he had given at his trial, and he persisted in declaring that Walter M. had no part in the crime. The steadiness of these assertions, in a man under sentence of death, and with nothing further to gain, was remarked upon, and it has been weighed by every account of the case since. On the 19th of November 1860, James Mullins was hanged. The execution was carried out in public, before an enormous crowd, for the hanging of a condemned murderer was still a public spectacle in England at that date, and the abolition of public executions lay some years in the future. The crowds that gathered for such occasions in the capital were very large, drawn from across the city to witness the carrying out of the sentence, and the execution of Mullins, following upon a case that had been so much discussed, drew a great concourse of people to the place of execution. To the last he maintained his innocence. Upon the scaffold before the assembled crowd, he declared once more that he had not committed the murder, and that Walter M. was an innocent man. He went to his death protesting both, and the sentence was carried out. The public character of the execution meant that these final declarations were made before a great multitude, and they passed at once into the account of the case, where they have remained. A condemned man's protestation of innocence at the scaffold was not in itself uncommon, but the circumstances of this case gave to Mullins's words a weight that has not diminished. With the execution, the legal process was at an end. James Mullins had been tried, convicted, and hanged for the murder of Mary Emsley, and the case was, in the eye of the law, resolved. Yet the resolution the law had reached did not close the matter in the judgment of all who considered it. The conviction had rested wholly upon circumstantial evidence. The prisoner had denied his guilt to the end, and the case contained within it the disturbing element of an attempted frame-up. These features, present from the first, ensured that the verdict, though it stood, would not stand unquestioned. The doubts about the safety of the conviction have persisted ever since. From the time of the trial to the present, the case of Mary Emsley has been cited among the most troubling of its decade, a capital conviction obtained upon inference in the absence of any direct proof. Some later writers have questioned whether the evidence against Mullins met the standard that ought to attend a sentence of death, and whether the chain of circumstance, however suggestive, truly excluded every innocent explanation. The very feature that told most strongly against him, his precise knowledge of the parcel's location, was capable of more than one reading, and the reading the jury adopted was not the only one that the facts allowed. It must be recorded, however, that no pardon and no exoneration have ever followed. The conviction of James Mullins stands as it was entered in 1860. No later proceeding overturned it, no authority corrected the record, and the doubt that attaches to the case is historical and scholarly rather than legal. The verdict remains what the jury made it, and the debate that has continued around it has not altered its standing in law. What survives is a conviction that stands in a doubt that has never been resolved, held together in a single case. The place of the case in the record is that of a Victorian cause célèbre of circumstantial evidence, a study in the difficulty of the inference upon which so many convictions of the period rested. It is remembered as the Grove Road murder, after the street in which Mary Emsley met her death, and it is documented in the proceedings of the Central Criminal Court and in the extensive newspaper coverage of 1860. The reward system, which had drawn Mullins forward with his false account, and which had shaped the whole course of the investigation, has been cited in later discussion as an instance of the perverse incentives that such rewards could create. The survival of the records has kept the case available to later examination in a way that many crimes of its period are not. The proceedings of the Central Criminal Court preserve the course of the trial. The inquest record preserves the finding as to the cause of death, and the newspapers of 1860 preserve the day-by-day account of the investigation, the trial, and the execution. From these sources, the case can be reconstructed in considerable detail, and it is upon them that the modern accounts of the Grove Road murder have drawn. The case has been retold in anthologies of Victorian crime, and it has been cited in discussions of the reliability of circumstantial convictions, but it has not passed into the wider cultural memory as the most famous cases of the century have done. It remains a case known to those who study the period and its criminal record, rather than a household name. The reasons for its comparative obscurity lie partly in the very features that have kept it alive among students of the subject. It produced no great literary work, no novel or play that carried its name beyond the archive, and it belonged to a decade rich in sensational crime, against which a robbery and murder in the East End, however troubling in its evidence, did not stand out to later generations. Yet within the narrower compass of Victorian legal history, it has retained a settled place, precisely because the questions it raised about circumstantial evidence and capital punishment were never resolved, and because the doubt that surrounded it was recorded at the time and has been passed down with the case ever since. The setting in which the crime occurred repays a closer attention, for the world of Mary Emsley's property was a distinct and characteristic part of Victorian London, and it bore directly upon the manner of her death. The eastern parishes of the metropolis in 1860 were a landscape of small ownership and small tenancy, in which a great part of the housing stock consisted of modest terraced dwellings, let out by the week to labouring families. The landlords of such property were not, for the most part, great proprietors, but persons of the middling and lower middling sort who had accumulated houses, one or a few at a time, and who managed them at close quarters. The economy of rent in these districts was an economy of small sums, gathered in person, recorded in books kept by hand, and turned to the purchase of further houses of the same kind. Within this economy, Mary Emsley had become an unusually large holder of a very common sort of property. Her more than 100 houses were not distinguished individually from those around them, but their number made her, in aggregate, a person of substantial wealth, and the manner in which she managed them kept that wealth in constant circulation through her own hands. The weekly rents of 100 and more houses passed to her in small payments, collected door to door, and the sums thus gathered were carried through the streets and kept, for a time, within her house. A landlady of this kind was a figure of the district's economic life, known to her tenants and her tradesmen, and known also to be in possession, at certain times, of money. The vulnerability that attended her position was of a particular kind. She was old, she lived alone, she kept no servants, and she handled money in the course of a business that brought her into contact with a large number of men of uncertain circumstance. The independence that had allowed her to build and manage her property without the assistance of an agent was the same independence that left her without protection in her own house. A woman who admitted tradesmen and tenants to her door in the ordinary course of business could not easily distinguish the honest caller from the dangerous one, and the pool of persons who knew her habits and her means was very wide. The circumstances of her death arose directly from the circumstances of her life. The reward of £300 that was offered for information in the case was itself a characteristic feature of the period, and its consequences in this instance illustrated the difficulties that such rewards could produce. In a district where the ordinary wages of labour were counted in shillings, the offer of so large a sum created a powerful inducement to come forward with information, and it created with it an inducement to manufacture information where none truly existed. The reward drew James Mullins forward with his account of Walter M., and it was the reward, according to the case the Crown afterwards made, that had furnished the motive for the frame-up. The system designed to bring forward honest witnesses had, in this case, brought forward a false one, and had, upon the prosecution's theory, supplied the very incentive that shaped the crime's concealment. The practice of public execution, before which James Mullins met his death, was likewise a feature of the period that would not long outlast the case. In 1860, the execution of a condemned murderer was still carried out in the open, before whatever crowd assembled to witness it, and the crowds that gathered for such occasions in London were among the largest that the city's public life produced. The spectacle of a public hanging drew observers of every sort, and the conduct of these crowds and the character of the scenes that attended executions were increasingly the subject of unease among those who reflected upon them. It was only some years after the death of Mullins that public executions were brought to an end and the carrying out of the sentence removed within the prison walls. The execution of 1860 belonged to the older practice, and the great crowd that attended it, and the declarations the condemned man made before that crowd, were possible only because the sentence was still carried out in public view. The figure of Walter M. deserves a settled place in the account. though the record of him is brief. He was a shoemaker who collected rents on Mary Emsley's behalf, a man drawn into the case by his connection with her affairs and by the false accusation of another, and he was innocent of any part in her death. The suspicion that first attached to him arose from the ordinary circumstance of his employment, and it was deepened by the deliberate design of the man who sought to fasten the crime upon him. When that design was exposed, the suspicion fell away, and M passed out of the case entirely. He returned to the obscurity of his trade and his ordinary life, and nothing in the record gives any ground to think of him as other than what he was, an innocent man who had been very nearly destroyed by the contrivance of another. His narrow escape is one of the elements that has kept the case in memory, for it stands as an instance of how close an innocent man might come to the gallows upon manufactured evidence. The medical and procedural elements of the case were, in their character, typical of the period's practice, and they were competently carried out. The examining surgeon determined the cause of death and estimated its time. The coroner's inquest inquired into the death and returned its verdict of wilful murder. The magistrates committed the accused for trial, and the trial was conducted at the Central Criminal Court according to the established forms. Each stage of the process was documented, and the documentation has survived, and it is from this survival that the enduring interest of the case in part derives. A crime whose records are complete offers to later examination a fuller ground for judgment than one whose traces have been lost, and the completeness of the Emsley record is among the reasons the debate over the verdict has been able to continue. That debate has turned, in every generation that has taken it up, upon the same central difficulty. The conviction rested upon circumstantial evidence, and circumstantial evidence, however strong, requires of a jury an act of inference, a conclusion drawn from facts that do not themselves declare the guilt of the accused. In the case of James Mullins, the inference the jury drew was that only the murderer could have known where the stolen property lay, and only the murderer would have sought to fasten the crime upon another. It was a powerful inference, and it satisfied the jury who heard the evidence. But an inference is not an observation, and those who have doubted the verdict have doubted whether the facts truly excluded every possibility but guilt. The case stands in the record of Victorian justice as one of the clearest instances of the weight and the peril of circumstantial proof in a capital cause. The property that Mary Emsley had built passed, upon her death, out of the story that the record preserves, and the particulars of its later disposition are not required for the account of the crime. What the case has left behind is not the fortune, but the questions. The record of an old woman killed in her own house, among the materials of her frugal trade, of an innocent man very nearly condemned in her stead, and of a conviction obtained upon inference that has never since been free of doubt. The street where she died has changed beyond recognition in the long years since, as the whole of the East End has changed, but the name of the Grove Road murder has survived in the histories of the period, attached to a case that the law resolved and that the judgment of later ages has continued to weigh. The manner in which the case was reported in its own day forms part of its record, and it shaped the public understanding of the crime while the events were still unfolding. The London press of 1860 gave the Grove Road murder a sustained coverage, following the discovery of the body, the offering of the reward, the arrest, the trial, and the execution in successive accounts, and the readers of the metropolis were kept informed of each stage as it occurred. The papers reproduced the evidence given at the trial, reported the demeanour of the prisoner, and carried the particulars of the execution and the declarations made upon the scaffold. It was through this coverage that the case entered the general knowledge of the city, and it was through the same coverage that the unease over the circumstantial character of the conviction was first expressed and preserved. The reward posters that were displayed in connection with the case belonged to the visible furniture of Victorian criminal investigation, and their appearance upon the walls and hoardings of the district was itself a part of the public experience of the crime. a large printed notice announcing the sum offered and inviting information was a familiar sight in the streets where a serious crime had occurred, and it served both to solicit witnesses and to impress upon the public the gravity of the matter. In the eastern parishes, where the reward of £300 represented a sum beyond the ordinary expectation of a labouring life, such a notice would have drawn a particular attention, and it would have set many minds to the recollection of what they might have seen or heard. The reward was an instrument of investigation, but it was also a public event in itself, and its effect upon those who read it was among the forces that carried the case forward. The reliance upon circumstantial evidence that marked the trial of James Mullins was not peculiar to his case, but was a recurring feature of capital prosecutions in the period, and it is against this wider practice that the particular anxieties of the Emslie case are best understood. Many of the gravest crimes were committed without witnesses, in private, and left behind them only the traces and circumstances from which the identity of the perpetrator had to be inferred. The law permitted conviction upon such evidence, and juries were regularly asked to draw from a body of circumstances the conclusion of guilt, and to do so to the standard that a capital sentence required. The difficulty was inherent in the nature of the proof, and it was a difficulty that the courts and the public alike were accustomed to confronting. What gave the Emslie case its particular place within this general practice was the combination of a wholly circumstantial conviction with the element of the attempted frame-up and the steadfast denial of the condemned man. In many cases resting upon circumstance, the accused offered no coherent alternative and made no protestation that survived examination, and the inference of guilt was drawn without lasting disquiet. In this case, the prisoner not only denied his own guilt, but insisted upon the innocence of the man he had himself accused, and he maintained both assertions to the moment of his death. The presence of a nearly condemned innocent man within the same case, and the survival of the accused's protestations in the public record, gave to the circumstantial character of the conviction a sharper edge than it might otherwise have possessed. The question that the case left unresolved was not whether James Mullins had behaved with guilt in the matter of the parcel, for his conduct in directing the police to the planted property was upon any view the conduct of a man deeply implicated in the concealment of the crime. The question was whether that implication established, to the certainty that a capital sentence demanded, that he was the person who had struck the fatal blows. A man might be guilty of handling stolen goods and of contriving to accuse another, and yet the further step to the murder itself remained a matter of inference. It was upon this distinction that the doubt over the verdict came to rest, and it is a distinction that the surviving evidence does not finally resolve. The tradesmen and the rent-paying tenants who made up the circle of Mary Emslie's acquaintance formed the human background against which the crime took place, and their number and character bore upon the difficulty of the investigation. A landlady who dealt personally with the occupants of more than 100 houses and who hired her workmen herself and bargained with them over their wages was known to a great many people, and any one of them might have come to her door without exciting remark. The investigation had to reckon with this wide field of persons who had access to her and knowledge of her means, and the narrowing of that field to a single accused was itself an achievement of inference rather than of direct observation. The very breadth of her dealings, which had been the foundation of her fortune, was also the circumstance that made the identification of her killer so uncertain a matter. The room in which she was found, the upper chamber where the rolls of wallpaper were stored, was a working space rather than a place of habitation, and its use tells something of the manner in which she conducted her affairs within her own house. The materials of her trade were kept about her in the room she occupied alone, and the business of letting and repairing her many properties was carried on from within the modest dwelling that was indistinguishable from those she let to others. She did not separate her fortune from her person, by any establishment of servants or agents or grander premises. The property was managed from the house, the money passed through the house, and it was in the house, among the stock of her trade, that she met her death. The plainness of the setting was of a piece with the plainness of the life that had been lived within it. The interval of several days during which the body lay undiscovered, while the blinds remained unmoving and the door unopened, is a circumstance that speaks to the solitude in which Mary Emslie lived. A person surrounded by a household would have been missed at once, but a woman who lived entirely alone might be dead for the better part of a week before the silence of her house drew notice. It was the absence of the ordinary signs of occupation, rather than the presence of any alarm, that at last brought others to her door. The community about her registered her life by the small external evidences of it, and when those evidences ceased, the cessation was slow to be understood, and slower still to be acted upon. The solitude that had been the condition of her independence was also the condition that left her death for some days unremarked. The estimate of the time of death, fixed by the examining surgeon at on or about the 13th of August, accorded with this account of the unmoving blinds, and the two circumstances together placed the crime some 4 days before the discovery. The killer, therefore, had come and gone while the household life of the street continued undisturbed, and the body had lain in the upper room through the days that followed, with nothing to mark what had occurred within but the stillness that the neighbours at length remarked. The concordance of the medical estimate with the external signs was one of the settled facts of the case, and it framed the whole sequence of events within a narrow compass of days in the middle of that August. The place of the case in the memory of the district was, for a time, considerable, for a murder of such a character, followed by so public an execution, was not soon forgotten in the streets where it had occurred. The name of the Grove Road murder attached itself to the locality, and the events of that summer were recalled by those who had witnessed the investigation and the trial and the great crowd at the execution. But the East End was a district of constant change, of houses built and rebuilt and streets remade, and the physical traces of the case did not long survive in a form that the passing generations could recognise. What survived was the record, the proceedings, and the newspaper accounts, and the later retellings, and it is in the record rather than in the streets that the memory of Mary Emslie has been preserved. The later writers who took up the case did so, for the most part, as an instance of the problems of circumstantial evidence and the perils of the capital sentence, and they returned again and again to the same features that had troubled contemporaries. They weighed the strength of the inference against the absence of direct proof. They considered the protestations of the condemned man and the narrow escape of the innocent one, and they set the case among the cautionary examples of its kind. None of them possessed evidence beyond what the record of 1860 preserved, and none could resolve the doubt that the original proceedings had left, but their continued attention kept the case within the discussion of Victorian justice and ensured that the questions it raised were not allowed to lapse. The case of Mary Emslie closes the record of these 3 cases. He died protesting his innocence and hers. The doubt he left has outlasted everyone who watched him hang.